I call this meeting to order. Point of order?
No, you start. I'll speak right
Okay.
after.
I call this meeting to order. Welcome to meeting number 20 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order of reference, Wednesday, May 18th, the committee is meeting to study Bill S-206, an act to amend the criminal code, disclosure of information by jurors. We will also go in camera to discuss the travel plan for this fall and adopt a budget. Today's meeting is taking place in a hybrid format pursuant to House Order of November 25th, 2021. Members are attending in person in the room and remotely using the Zoom application. The proceedings will be made available via the House of Commons website. For those on Zoom, you have the choice at the bottom of your screen of either floor, English, or French. For those in the room, you can use your earpiece and select the desired channel. I'd now like to welcome our witnesses. First, Mr. Michael Cooper, Member of Parliament for St. Albert, Edmonton, also a member of this committee, as well as Mark Ferrant, Founder and Chief Executive Officer of Canadian Juries Commission. So I will, Mr. Cooper, it's at your liberty. You said you only wanted 5 minutes, but you have up to 10, and Mr. Ferrant, the same thing. However succinct you'd like to make it, I'll let you guys take it from there. Thank you.
Thank you very much, Mr. Chair and members of the committee. It's an honor to be here to present, as the House of Commons sponsor, Bill S-206. 3 years ago, I appeared before this committee with Mark Ferrant to testify in relation to my then private member's Bill C-417, which is substantively the same as Bill S-206. Just as Bill S-206 has received unanimous support at all legislative stages thus far, Bill C-417 passed the House at all legislative stages in the House of Commons with unanimous support, but unfortunately did not make progress in the Senate due to the call of the 2019 election. I'm hopeful that that will not be the case with Bill S-206. This legislation is a straightforward piece of legislation. It seeks to implement a key recommendation of the unanimous report of this committee on jurors' supports, a study that I had an opportunity to participate in as a member of this committee. More specifically, Bill S-206 carves out a narrow exception to the jury secrecy rule, whereby former jurors who are suffering from mental health issues arising from their jury service can disclose all aspects of that service, including the deliberation process, with a medical professional bound by confidentiality. As it currently stands, Section 649 of the Criminal Code makes it an offense for a former juror to discuss any aspect of the deliberation process with anyone for life. There is but one narrow exception relating to an investigation or criminal proceedings in relation to a juror for obstruction of justice. During our committee's study on juror supports, we heard from a number of former jurors, including Mark Ferrant, who was a jury foreman in a gruesome murder trial. All of these former jurors had gone through difficult trials, been exposed to horrific evidence, and suffered from mental health issues, in some cases PTSD, and in some cases for decades after. These former jurors are not alone. Thousands of Canadians each year take up the summons to serve on a jury, many of whom go through difficult trials and suffer from mental health issues as a result. The deliberation process we heard at the study around juror supports is one of, if not the most stressful aspect of jury service. After all, it is where, as a juror, you are sequestered with other strangers, where you have to go through and difficult evidence, sometimes again and again. There is enormous pressure to make the right decision, having regard for the gravity of rendering a verdict in terms of potentially putting someone away for life, as well as seeing that justice is done. And so it begs the question, if one who is suffering from mental health issues arising from jury service cannot talk about what may be the core of their injury, how is it that they can get the full help and support they need? And that is what we heard at this committee 4 years ago when the committee undertook its study, that indeed the jury secrecy rule can be an inhibitor for jurors getting the full support that they need, being unable to talk about what is the core of their injury or could be the core of their injury, as well as creating difficulties around having full and frank discussions with medical professionals. That is where this bill comes in. It carves out a narrow exception, all the while protecting the integrity of the jury secrecy rule. There are many good reasons for the jury secrecy rule, including respecting the finality of a verdict, protecting the privacy of former jurors, and protecting the sanctity of the deliberation process. This carve-out would not impact any of those objectives because, again, any disclosure would be post-trial in a strictly confidential setting. This is a common-sense piece of legislation that is much needed and will go a long way to support juror mental health in Canada. Thank you, Mr. Chair.
Thank you, Mr. Cooper. Now to Mr. Ferrant.
Thank you, Honourable Committee Chair and members of the committee, for inviting me here today. My name is Mark Farrant. I'm the founder and CEO of the Canadian Juries Commission, a national not-for-profit organization supporting and representing Canadians serving on jury duty and coroner's inquests. Jury duty is an essential component of our Canadian democracy and our justice system. Entrenched in our Canadian Charter of Rights and Human Freedoms, the right to a fair trial and the right to be tried by a jury of one's peers is something to cherish and protect in these times of global unrest and uncertainty. Every year, thousands of citizens answer a summons and step away from their families and workplaces to attend a trial, observe evidence, and deliver a verdict, often in difficult and disturbing cases. For some, jury duty is a rewarding experience where jurors take pride supporting the justice system and their communities in court. For others, jury duty is extremely challenging and even life-altering. While jurors are addressed as officers of the court and judges of the facts, jury duty is not a vocation. Jurors represent the conscience of our society but have no preparation for their experiences in court, no special training, and indeed no foreknowledge of the trial or its contents. First responders and jury members are bookends of the justice system. Jurors deliver the verdict for the very same crimes answered by first responders and investigated by police. Jurors are exposed to the same graphic evidence of human cruelty, violence, homicide, sexual assault, and unspeakable acts. Jurors do not have the opportunity to turn away from evidence. Indeed, must often view it over and over again. This is the burden of jury duty, along with the task of reaching a verdict based on facts and evidence. But unlike first responders and other actors in the courtroom, jurors do not have access to evidence-based treatment, counseling, and support networks to process the experience or the necessary professional training to manage disturbing testimony and physical evidence. We now understand the toll these crimes have on those working in public safety and our courts, resulting in PTSD, depression, and significant mental illness. Collectively, Canadians have worked hard to destigmatize mental health and promote treatment. We have established programs for first responders to support them in their healing, respecting the important work they perform for our communities. Jurors are in many ways the most vulnerable to trauma and sadly receive the least amount of support compared to others in the courtroom. Yet, jury duty is a civic duty, but it's not a duty to suffer. Yet many jurors have reported difficulties post-jury service accessing adequate support, especially in jurisdictions where offering no post-trial support at all. In some cases, clinicians have been reluctant to treat former jurors due to the jury secrecy rule and the threat of legal repercussions. The jury secrecy rule also has prevented jurors from having a free and open discussion within the confines of therapy. Deliberation is the most stressful component of jury service, according to former jurors, with many describing it as one of the most difficult experiences of their lives, above other common life events. Jurors have reported experiencing intense feelings of shame, guilt, remorse from delivering middle ground verdicts in difficult trials. Jurors have reported grieving for decades because of their verdict, a decision that in many cases was the only one available given the evidence. But these same jurors have been unable to process this experience and move beyond it due to the jury secrecy rule. How can we unpack psychological trauma and develop coping mechanisms if jurors are unable to discuss the very thing causing them harm? This refutes the very foundations of psychology and mental health practices. Committee members, Bill S-206 represents a very narrow exception to Section 649 of the Criminal Code that will go a long way to improving juror mental health and making a measured difference in the lives of jurors long after their jury service. This is a long overdue investment in jury duty that will improve Canadians' willingness to participate in jury service and build confidence in the justice system. We owe jurors our thanks for their service. We also owe them every means possible to move beyond negative experiences in court and return to their lives and families. Thank you, committee members, for inviting me here today to speak with you.
Ferrand. Now we'll go for our first round of questions, and just in the hope of time, just some efficiency, we'll do 5-minute rounds for the first round, and then 4 for the next 2, and then 2 minutes for the next, if that's okay. I think I already spoke to Mr. Cooper, just in the efficiency of time, if we can do that. We'll begin by Mr. Morrison for 5 minutes.
Thank you, Mr. Chair, and thank you for the witnesses. I've got some hard questions for Mr. Cooper, but I'm actually going to start off with Mark. Mark, I want to thank you for coming today and for helping us with identifying with PTSD, and especially with jurors. I mean, I've got a long career in the RCMP, and it's a silent disease that is really hard to recognize, in fact, usually ignored. You know, and in policing, you get tough, you can handle it, but that's not true at all, actually. Even though, you know, I've seen lots of horrific things, it's still, there's lots of people. It affects everyone differently. Everyone's unique. And to have our jurors, who we rely on, you're right, for democracy, to have them afraid or suffering for years is just unacceptable. So I applaud. I'm very happy you're here today, and thank you for your struggles you've had to help others that are going to go through exactly the same thing. One of my questions I have is how do you feel we are going to be able to encourage people to come forward to get the help? Because a lot of people are probably afraid to come forward because they're embarrassed that, you know, something at a trial bothers them.
We've seen, thank you for the question, and thank you for your kind remarks. We've seen justices on the bench, once the verdict has been delivered and the jury is thanked and excused, actually delivering that message themselves. So justices now are slowly coming forward and saying, especially in provinces where support programs are available, reminding the jury that those programs exist and encouraging them to talk about the experience and not being embarrassed about it. It's not universal, though. Not every justice does that. The Canadian Juries Commission has been working with the National Judicial Institute on that basis, and we're hoping to come forward with some programs specifically for justices to remind them that jurors do experience trauma and that they have a role too to encourage support post-trial.
How do we encourage previous jurors to come forward? How do we go back in time and just check up on some of the jurors who haven't had this opportunity?
A lot of it is advocacy and work in the public sphere. 2 weeks ago, we were very pleased to have the first ever Jury Duty Appreciation Week in Canada, our first ever week, and that's an opportunity too to thank jurors collectively and to provide them with support and encouragement. That's an opportunity to thank jurors past and present from decades ago for their service, and an opportunity to again talk about mental health and the importance of it.
Yeah, great. It's awesome. Mr. Cooper, harder question maybe. This is to me is way overdue. Like, I mean, I can't even imagine why we haven't gone down this road historically with knowing some of the traumatic, incidents that people have had to deal with. What's taken so long to get this far?
Well, I think to some degree there was a lack of awareness, at least on the part of parliamentarians. The juror support study that we conducted was the first of its kind. It never before had a parliamentary committee undertaken such a study. And it was in the course of that study that we really heard compelling testimony from Mark and from other former jurors that I think really highlighted some of these challenges. And it was in the course of the study that we heard from witnesses who talked about the jury secrecy rule and specifically cited the Australian state of Victoria, where such an exception exists and has been implemented quite successfully. And that is precisely what this bill would do, is implement the same exception that exists in the state of Australia, Victoria and Australia.
Well, I want to thank both of you for being here today. To me, it's just nothing but positive move forward for Canadians and for jurors and helping people with PTSD. Thank you for that.
Thank you, Mr. Morrison. I'll next go to Madam Diab.
Thank
for 5
you.
minutes.
Thank you very much, Mr. Chair. And I have to agree with you, Mr. Morrison, on this one. Quite frankly, Mr. Cooper, I want to congratulate you for sponsoring this. I really do. And Mr. Farron, thank you very much for your advocacy. As someone who practiced law 22 years before I went into provincial politics myself, I had a number of people that would come to me scared to death when they got the letter in the mail that they have to go and be on a jury, and had no idea what it meant and what it even means. And this is before they even stepped into a courtroom, because for most of these people, they would have never been in a courtroom in their life. And they're trying to figure out, how do we get ourselves out of this? Do we have to do this? All of that. I've never had the occasion for anybody to come back, though, after. So I can only imagine that, some of the trials where, the horrific things that they would hear. It's so, and just from listening to you now, so this is a non-brainer, but I have to confess, it's not something I would have even thought about. And so for those that preceded me on the, Mr. Cooper and whoever else the last number of years, really congratulations, because this is what we are here for as parliamentarians, to improve the lives of Canadians. And in this case, it's jurors who we really need. So, Mr. Farron, you talked about that there are provinces that offer support programs, and I don't know which ones, quite frankly, do or don't. What can you see after the passing of the bills? What are some a couple of things that you would like to see provinces and territories, perhaps the federal government, do to support jurors.
Thank you for the question. Thank you for your comments, too. Greatly appreciated. We've been advocating for a national standard for post-trial support for jurors, as it is a federal mandate jury duty that is administered by the province. Thus, no one should have to look over the fence at the province next to them and wonder why they have juror supports in that province and why my own province has nothing to offer me. That's a terrible scenario to be in, and I've spoken to jurors who've experienced that. Ontario, through the leadership of Yasir Naqvi, in fact, instituting the Ontario Juror Support Program, Saskatchewan, BC, and Alberta have established juror support programs. There are many provinces that have nothing at all, or a very cumbersome means to achieve support, having to go and acquire counseling on your own, which anyone would understand. Accessing mental health is very difficult. We know that there are waiting lists, and especially if you're experiencing trauma from your civic duty, that's a difficult situation to be in. So a national standard would be appropriate. Not restricting the number of sessions that are available to a juror. So some of those programs only offer 4 sessions of counseling, some with an additional 4. And anyone who's been through therapy would understand that sometimes 4 sessions you're barely even unpacking the problem, let alone getting to a solution and coping mechanisms. And so thus you're sent out the door not having any structure or any follow-up, and still left with a nagging issue. And PTSD is a very complicated disorder. It's not something that can be solved immediately in 4 sessions. It requires cognitive behavioral therapy, and it requires a number of sessions.
Let me get one more point if I have any few seconds, and I can direct that to either one of you. I really, really, really appreciate where you talked about you had a jury duty appreciation week in Canada for the first time. I think when I heard that, I thought it is really a good thing to do, because most people are scared to death to even, when they get that letter and are asked to do that. So perhaps, Mr. Cooper, as parliamentarians, perhaps there's something we can do to raise awareness, I think, and encourage people that that's a good thing, and, not to be scared, but at the same time that there may be help for them if they need it at the other end.
Well, thank you very much, Ms. Diab, and I very much appreciate your very kind comments. And this bill actually will increase confidence, I believe, in people who are summoned to know that they will be able to get the full help that they need, that they won't be inhibited by the jury secrecy rule. So from the standpoint of encouraging participation, I think this bill is a step in that direction.
Thank you very much to both of you.
Thank you, Ms. Diab. Next, we will go to Monsieur Fortin for 5 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Mr. Cooper, thank you for being here. Mr. Ferrand, thank you as well. I know your talents as a parliamentarian, Mr. Cooper, and I have no doubt that this bill is in good hands. So thank you for doing this. I think it's an important subject. It's an important subject because the role of jurors, is an important role in our society, and I've already discussed with Mr. Ferrand, and I'm very pleased to see that you're here today to testify before the committee and to shed light on different aspects of this with regards to the bill. So I would like to join my voice to that of my colleagues on the importance and the need to recognize in our society the role played by jurors. This is an essential role, and I think that Juror Appreciation Week, yes, that's good, but we could go even further. I think that we could do more with regards to recognition for those who accept to serve. I agree with all of this. I do have a few questions. I don't have reserves per se. I understand the idea here of of the need to consult with a healthcare professional. I don't have any a problem imagining how traumatizing this can be for a member of a jury. But I do have a few questions. Mr. Ferrand, you've already been a juror and you've gone through the experience. I'm not going to ask you to tell us to what extent this can be traumatic, because I believe we're already convinced. I'd like to hear you speak, though, on what's important for a member of the jury. I understand help, recognition, but when you're a member of the jury right now, there's a rule that says that everything that is said stays confidential, remains confidential. And so the idea is to allow members of the jury to feel at ease in expressing their point of view. If you've chosen 12 members of the jury, it's because you want these people to think together as a team. You don't want for one person to determine to decide the guilt or the innocence of the accused. You want this to be a thought process with 12 people. And so this process has to be free, has to be open. And so my fear is that by saying members of the jury could afterwards consult a healthcare professional, this opens up a type of there's a type of opening here that's created. It opens up a gap, and I'm wondering what impact this gap could have. For example, as a former member of the jury yourself, how would you react to this? You're sitting around a table with 11 other people, knowing that one or more of these individuals could repeat what you are saying to a therapist eventually. Doesn't this concern you?
Thank you very much for the question, and thank you for your kind comments as well. I don't think that this bill would impact both the jury's ability to deliberate as instructed through the charge from the justice and through the rules of the court. Jurors follow instructions to the letter, and they take their role extremely seriously. And the idea that that they might reflect on a mental health, the ability to disclose their deliberation after the fact isn't going to affect their decision-making process in the back room, in my estimation. Jurors are deeply committed to the process, are deeply committed to following the charge that is presented to them. That is, on top of it, one of the stressors that they experience is their deep commitment to the practice and why deliberations tend to go 5 days or longer because of that commitment. I think, but it sends a message to them that the system that they are supporting is also supporting them after the fact.
Je pense que mon temps est écoulé, Monsieur le Président.
I think my time is up, Mr. Chair.
Merci.
Thank you.
Thank you, Mr. Fortin. I think Mr. Garrison's next, but he wanted to.
Thank you, Mr. Chair. I certainly have nothing to add to this debate and think we need to get moving. But I also know that one of my colleagues has parental responsibilities sometimes that constrain his schedule, so I'd like to give my time at this point to Mr. Navke.
Thank you very much, Mr. Garrison. I really appreciate it. And Mr. Ferrand, it was good to see you again. Thank you for being here. Thank you for your steadfast advocacy on this. You're just really inspiring. And Mr. Cooper, thank you very much for carrying the torch on this on the House of Commons side. Really very much appreciated. Mr. Ferrand, I'll ask two questions perhaps for you. One is, can you share with us in your analysis the American experience, and is there lessons we can learn from there in terms of how juries are treated? I'm sure they probably differ from state to state, but are there things that Americans are doing that could be helpful insight for us here in Canada when it comes to providing supports for jurors?
Thank you for the question. In some ways, Canada is actually the leader in post-trial support and mental health support. In most American states, there is no support at all to jurors post-trial, and every state is very uniquely different in the way that they manage jurors. Canadians have taken leadership in improving jury pay in many provinces. And jury pay in the U.S. is substantially lower. In some cases, $6 and $10 a day for jury service, which is feeding some of the reticence and resistance to respond to a summons in the U.S. In many states, people just aren't even showing up in court. They're not even in the courtroom. And in some cases, the sheriff has had to go to houses to knock on the door to canvass to find out why they weren't coming to court. Obviously, jury secrecy is very different in the U.S. than it is here. I think Canadians, from the research that we've conducted in focus groups and talking to jurors, Canadians appreciate their ability for privacy that is afforded under the jury secrecy rule, in the sense that they're not questioned by the media, that there isn't scrutiny on the decision. That has an added benefit to the jury, in the sense that they're protected and they can return to their lives, and their identities aren't disclosed, and that is very much appreciated.
Okay, thank you. And my final question to you would be, so this is an important step, and hopefully this bill will pass this committee and back into the House and will become law eventually. I'm sure there is a Canadian Juries Commission has a fairly lengthy list of things to do. What next needs to happen to provide for appropriate supports for jurors?
Well, we're very pleased and honored to be working with the Attorney General of British Columbia and the BC Supreme Court through funding from the Department of Justice on our juror support pilot project. We are training BC sheriffs who manage jurors on a day-to-day basis. We're training them on self-care, resiliency skills, the juror experience, the journey of the juror, and identifying the stresses that many people just don't know and understand that jurors experience. Providing BC sheriffs with that training to support the jury in court and to provide subtle supports so that after a difficult day in the courtroom, the sheriff can provide some empathy and support so that the jury can come back in the next day and continue that work. It's not opinionating the jurors. It's not intruding on their objectivity. It's providing empathy and support to them. We're also developing a peer support pilot project. We're training former jurors who have lived experience and have been through the system and been through graphic trials, training them to provide empathy and support to jurors as an alternative and complement to the post-trial support programs that are there now. Our goal is to nationalize those two programs in addition to some of the other work that we want to do. Certainly, we hope that Canadian Jury Duty Appreciation Week will be a designated event in the calendar for all Canadians to celebrate jury duty and thank the jurors for their contribution.
Thank you very much.
Thank you.
Some of the remaining time back.
Thank you. We'll now go to Mr. Brock for 4 minutes.
Thank you, Mr. Chair. Thank you, gentlemen. I'll start off with my colleague, Mr. Cooper. Proud moment, Mr. Cooper, for you. It's a proud moment for me to consider you a colleague. Tremendous work went into this particular private member's bill. You should be very proud of your advocacy on this issue. There's a couple of questions I do want to ask, just so I can have this clear in my mind. I took a look at the language under the new exception to the jury secrecy rule, And there is a phrase that gives me a little bit of concern. Perhaps you can shed some more light on it. So the concept of speaking to a medical or psychiatric official or a therapist or a counseling after the completion of the trial. So again, I wasn't here 4 years ago when this was debated and discussed. Can you provide some sense as to what that legally is defined at? Because we all know after verdict could mean after trial, or is it after sentencing? Quite often there's a significant passage of time between verdict and sentencing. So what was contemplated and how are we to interpret that particular language in this bill?
Yeah. Thank you, Mr. Brock, for that question, and I believe an answer to it that what is contemplated is after the verdict. After verdict.
Okay, good to know. Second question, I think it's a follow-up to my colleague, Mr. Morrison, in terms of the retroactive perspective on this legislation. There's no limit as to whether or not we're talking about current jury composition. Was it contemplated that any past jurors from decades ago who are still suffering, who now find out about this particular new piece of legislation, can now take advantage of it? I see that Mr. Ferrand is acknowledging that by shaking his head.
I would anticipate that would be the case. The idea is that we've spoken to jurors who 20 years have been suffering with this this sense of shame and guilt, from an acquittal that was otherwise impossible to have gone any other way. And they take that as a sense of personal ownership, and so have been reticent to talk about it, reticent to and unable to talk about it because of the secrecy rule, and taking that responsibility. Jurors do take their responsibilities very serious, and when Canadians are told not to discuss the confines of court, they don't. They don't talk to their spouses about it. They don't talk to coworkers about it. They don't talk to anybody about it.
I think that's what distinguishes our system of justice from the Americans. You've identified what I always knew to believe, like we have a paltry remuneration system here in Canada, but it still pales in comparison to the pennies that they receive in the United States. So it's no small wonder that the moment there's a verdict, they're looking for the press. They're looking for a publicist. They want to talk about the evidence. They want to make some money off of this. There are professional people who want to be on juries. I don't think that makes for an effective justice system, in my view. I come from a 30-year career as a lawyer, the last 18 years as a Crown prosecutor, and I think that's what makes the Canadian judicial system so special, because it starts literally the moment the judge gives instructions. I could see it in their faces, how serious and how solemn this particular oath is. And I can only sympathize, and I was really touched, Mr. Ferrand, when I read a little bit more about your story. I just did a Google search, read about the case that you were particularly involved in and the struggles that you went through, and clearly the help that you received professionally at CAMH, and now the strong advocacy that you're doing, I think is just tremendous work. But it's so important that we as parliamentarians use whatever tool that we have in our toolbox to offer that assistance. This is certainly a step in the right direction. And to both gentlemen, 4 years ago, was there any sort of discussion about advocacy or learning opportunities for the judiciary and the lawyers, the Crowns, the Defense Counsel, ways that they could assist juries in the process as well?
Unfortunately, we're out of time. If you have something really quickly, you can add it, sure. Very briefly.
Under this particular bill, no, there weren't discussions along those lines, but we are working with the National Judicial Institute as we've done some plenaries with them, and we have every reason to believe that we'll be producing some education programs for justices and other actors in the courts.
Thank you. Thank you, Mr. Brock. To Madam De Bruzen for 4 minutes.
Thank you. So this is actually a pretty big day. I'm a little bit emotional about it when I think about where we started, Mark. So first, a big thank you for all the work that you did. And as a message that advocacy matters. I mean, you've been tireless. I met you many years ago when you started working on it, and since that time you've put together the commission. You've worked with Michael, and big shout out to Michael for making this day happen to get this bill. So really, I think there's a message for people, anyone who would be watching. Advocacy matters, and you took this and you really made a difference. So thank you for that. You talked a little bit earlier about some of the next steps you saw with the provinces and the work that you were doing with the provinces. But there was a big study that was done by the Justice Committee as well a few years back. What would you be prioritizing as next steps that you would like to see for juries from a federal level?
Thank you for the question, and thank you very much for your comments as well. And it has been a long road, hasn't it? The report had 11 recommendations and this bill was derived from that report. In fact, the commission, the Canadian Juries Commission, was born from that report. We took it upon ourselves, because there was limited action on some of the other recommendations, to take that on ourselves and advocate directly with the provinces. Certainly, we know that there's a responsibility at the federal level to provide resources to the provinces to assist them in such things as raising jury pay. Raising jury pay is the best catalyst to improving diversity and representation on juries in this country. If we're talking about systemic racism within the justice system and identifying barriers, simply raising jury pay will almost overnight allow people who are otherwise shut out of the justice system the ability to afford to serve on a jury. Even the recommendation made all those years ago at $120 per day is now actually out of date because of rising inflation and the cost of living. That figure should probably be now $150 a day. I think jury duty should be talked about amongst the meeting of the premiers, and I think there's a responsibility to bring that discussion forward, because it is the last mandatory civic duty left in our country. There's nothing else. It's our only civic responsibility left.
Thank you for that. And you know what? I don't really have much more to add. I will say there are very few times that you get a table that is basically asking very kind questions and being really supportive. That's a sign that this is a bill that I'm hoping we have, I think, 2 clauses to get through after this. Hopefully it'll go very quickly. We can bring it back to Parliament quickly and really just help shepherd it. But from the sounds of it, you have a lot of support around this table, so that's a great thing to see. Thank you.
Thank you, Ms. De Bruzen. And now to Monsieur Fortin for 2.5 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. I don't have a lot of time, so I reiterate that thank you very much for being here. But I do have these same questions, and we don't have enough time in 5 minutes and then 2.5 minutes. It's hard to delve into this, but I would address my question to Mr. Cooper, if you'll allow, Mr. Ferrand. Mr. Cooper, having worked on this, the former iteration, and on this one, I would like to know, did we, because I didn't see where we talked about the negative impact. I'm not trying to play devil's advocate, but I know that in Quebec, for example, the ethics code obligates professionals to keep confidential discussions that they have with their client. And this seems to be quite airtight, if I might say, but sometimes the professional might be authorized to disclose what the patient has said. For example, if they're sued, if the law allows it, if they want to prevent an act of violence, if someone is talking about suicide, the healthcare professional can disclose what's being said, even in confidence. So even if these are extreme and rare cases, it is a possibility. So this is what I was talking about, a possible gap or a breach in confidentiality. And so I'm quite concerned about this. Could you reassure me? Has there been any studies, Mr. Cooper, to your knowledge, on this possibility of the impact that this might have on the jurors that have to have full confidence in confidentiality to express themselves freely? Do we have any studies on this particular issue?
Well, thank you very much, Monsieur Fortin, for that question. And what I can say is that based upon the experience in Victoria, it has worked well. And as the committee understood it, there have been no issues that have arisen from this exception in the state of Victoria. With respect to the stakeholders that appeared before this committee at the time, there was unanimous support for it from former jurors, from members of the bar, including the defense bar, from mental health professionals. And so this is one of those few bills, as Ms. DeBruzen pointed out, in which there is seemingly unanimous support from parliamentarians and from all stakeholders. So,
I know it's unanimous, but there has been no study done as to will the jurors feel less comfortable, less confident? So this has not been studied.
Thank you, Mr. Fortin. And as Mr. Ferrand said, from his experience as a former juror, that he doesn't believe that this will impact upon the ability of jurors to deliberate. But what it will do is ensure that those former jurors who are suffering can be able to get the help they need. And it's not just about disclosing to a medical professional the deliberation process.
Thank you, Mr.
It's sometimes uncertainty about where the boundaries lie. Medical professionals sometimes are even reluctant to take on former jurors as clients because of uncertainty around the jury secrecy rule. This bill helps clarify that and will help former jurors in that regard.
Mr. Cooper, thank you. Thank you, Monsieur Fortin. Just for the record, I give you 4 minutes, so I've never cut you short. Thank you. I want to thank Mr. Cooper and Mr. Ferrand, and especially to Mr. Cooper. It's quite the honor when.
Mr. Cooper qui a parlé trop longtemps.
It's not my fault. It's Mr. Cooper who went on.
But thank you. And now we'll go to clause by clause. So if I can ask the legislative clerks to come forward and just give them a few seconds. This part's still not in cap.
Maybe we should suspend maybe 1 minute just.
You want me?
Yeah, Philippe, mesdames.
Chair, a point of order. Yes. Mr. Zuberi has advised that he's having some technical difficulties. I'm wondering if we could make sure that he's on and able to vote.
Yeah, we're just going to suspend for 1 minute, just technical difficulties getting in one member on, so we'll just suspend for a minute. we have witnesses as well. We have Samantha Reynolds from the Department of Justice, Criminal Law Policy Section. I think she's online, so she'll help us with any questions that anyone may have. I'm assuming this will go relatively smoothly because it's by consensus. The chair calls Clause 1. Shall Clause 1 carry? Agree? On division? Do you want to record and vote? We all agree. It's unanimous, yeah. Yep. Shall Clause 2 carry? Shall the title carry? Shall the bill carry? Shall the chair report the bill to the House? That's it? That's only a bit. So we're all good. This will be reported to the House, and we will now again suspend for a minute just to go in camera. And I want to thank Mr. Cooper. Thank you, Mr. Ferrand. Thank you, Mr. Cooper. Well done. And we'll suspend for 1 minute. A new link will be sent to, 5 minutes. And Mademoiselle Dillon, you'll get a new link, and anyone else that's remotely doing it. Yes, it'll
you.